questions. Could you please explain some of these fines and how people with relevant entities can avoid falling in the line of fire?
Sure, thank you, Matthew. Yes, as you rightly say, in this part of the webinar, in response to that question that you just raised, we're going to consider the enforcement guidelines common reporting standard that have been published by the Tax Information Authority, also known as the TIA, here in Cayman. These guidelines outline the circumstances in which financial institutions can have penalties imposed as a result of non-compliance with the common reporting standard, known as CRS obligations. The guidelines also contain useful information on other related topics, which I'll touch on briefly, such as the method by which penalties are imposed and the ability of an affected party to object to any such penalty. By way of a brief recap, CRS is an international standard for the automatic exchange of information between tax authorities of participant countries who have opted to adhere to CRS. CRS was introduced almost a decade ago by the Organization for Economic Cooperation and Development, known as the OECD, and it is a global initiative to reduce tax evasion and aggressive tax avoidance by requiring tax authorities of the participant countries to routinely share information acquired from persons within their jurisdictions. The guidelines were first published in March 2022 and have been updated most recently in June. The guidelines set out the TIA's approach to the taking of enforcement action by imposing penalties on persons who fail to meet their CRS obligations. The Tax Information Authority International Tax Compliance Common Reporting Standard Regulations of the Cayman Islands set out the core elements of the CRS framework in Cayman and the applicable obligations. Part 4 of the regulations sets out the general nature of the offences under the CRS regime, and Regulation 24 sets out the financial limits of the applicable penalties. I've included an extract of Section 24, of Regulation 24 rather, on the screen there, and you can see that the fines can be quite significant and up to 61,000 United States dollars. The figures that you can see on screen there are in Cayman Islands dollars, and you can also see at the bottom there in subsection 2 towards the bottom that there can also be imposed additional daily penalties in certain circumstances. However, the regulations themselves are a little bit short of detail in some respects, because they don't specify the circumstances in which the penalties can be imposed, nor the amount of those penalties. The regulations also don't provide for any kind of appeals process, and this is where the guidelines come in. Section 2.3 of the guidelines sets out a non-exhaustive list of the circumstances in which the penalties provided for in the regulations may be imposed, as well as the indicative, and I emphasize the word indicative, administrative penalty that might be imposed for it. And you can see the examples on the slides there. Again, the currency stated is in Cayman Islands dollars, and so for comparison purposes, 7,500 Cayman Islands dollars is approximately 9,150 US dollars, and 10,000 Cayman Islands dollars is approximately 12,200 United States dollars. The stated administrative penalties are the amount that is payable per offence, and so multiple breaches would each attract the relevant fine. So as you can see from the amount stated there, non-compliance can very quickly become very costly indeed. The guidelines also provide insight into how the TIA will investigate suspected breaches. For example, an investigation will not be necessary in all cases. For example, if the breach is a simple failure to file documents on time, they won't waste time with an investigation. If an investigation is carried out, this can take a number of forms, such as a compliance questionnaire, a desk audit, or an information notice. The route that's taken by the TIA in each case will depend on the circumstances and what it considers to be the most appropriate. Before it actually imposes a penalty, the TIA is required to serve first what we call a breach notice. That will give the affected party a deadline, which can't be less than 60 days from the date of the breach notice, to submit any representations in support of its position. That notice will also state the amount of any proposed penalty. Once received from the affected party, the TIA will consider any representations that have been made and will then reconsider its position. Any representations from the affected party may only be made by email, and depending on the status of the affected party, those representations may have to be submitted by the PPOC or principal point of contact. Having considered any representations, the TIA may take a number of steps. They might impose the full amount of the proposed penalty. They might reduce the amount of that penalty, or if the breaches have been remedied, they could revoke it altogether. If a penalty is still imposed, then the TIA must serve what we call a final penalty notice. The guidelines clarify that if a penalty notice is served, then the affected party may appeal to a court against the decision to impose that penalty. It can appeal the amount of the penalty, or it can appeal both. Any appeal must be made within 60 days of the date of the final penalty notice, and whilst the hearing of the appeal is pending, the TIA is prevented from enforcing payment of it or claiming interest on it. So we are often asked, or have been asked regularly since the guidelines came into effect, what can be done to avoid the investigations and the imposition of the notices of breach, and most importantly, the imposition of a penalty notice. Given the sheer breadth of the obligations under CRS and the many possible types of breaches and the circumstances that can lead to the imposition of a fine, there is unfortunately no single solution. But there are a number of effective steps that can be taken in order to avoid the likelihood of this happening. And these are as follows. Some matters under the regulations require what we call self-certification. And it is an offence if anything contained in a self-certification is incorrect, and the affected person either knew or should have known that it was incorrect. Entities should therefore ensure that there are appropriate procedures in place for completing self-certifications, and that the person in the organisation who's responsible for them is made aware of and critically has access to all relevant information pertaining to that self-certification in order to avoid any unfortunate errors. Secondly, we recommend that the circumstances of each legal entity be considered at least annually to ensure that all registrations and factual information remain correct and accurate. If they are not correct and accurate, then naturally steps should be taken to update the relevant details so as to avoid any breaches. And thirdly and finally, we would recommend that written policies and procedures be properly maintained as required by the regulations, and critically that those policies and procedures are reviewed at least on an annual basis to ensure that they are correct, complete, and most importantly, reflective of the entity's then current activities.